Roan Waring for the city of Memphis. I'd like to reserve maybe 2 minutes in rebuttal.
2 minutes, all right.
I'm not even sure I'm going to need that, sir. This is a case that arises from the, originally from the termination of a firefighter, or rather an EMT, because of his smoking marijuana. And I don't need to recite my brief to you, but just hit the high points in the history of the case. And it's simply, and I know, Judge Golden, you've dealt with a number of these kind of cases because I've read them, dealing with these terminations through the the Civil Service Commission and the appeals that are taken from there. The appellee, Karl Jackson, was a firefighter EMT for 20-something years, 24 years, I believe, all total, with the Memphis Fire Department. He is back in 2014. He was given a random drug test, and it scored positive for marijuana. He was opted to go into a safety workplace program where he was monitored and was tested on a monthly basis for 4 years. And he understood that at the end of the 4 years, if he got out, that he could never fail another drug test, never fail another drug test, or he'd be automatically discharged.
What does that mean, fail a drug test?
The test scores taken from his, in effect, urine samples would indicate that his sample was over the limits, the cutoff limits.
So what's the cutoff limit?
Well, I believe it's 50 milliliters per something, and anything above that or above, indicates positive for marijuana.
So is this a zero tolerance policy? If you've been through this program and as you say, you can't test positive for anything again, I'm trying to figure out what exactly the procedure is.
Oh, well, actually, after he finished this procedure or reinstatement possibility from 2014, he was able to, he did so successfully, he was able to not apply for, but rejoin
right. Well, I'm just, if you've been through this program.
Yes, sir.
And you've successfully completed the program, you still have the first infraction out there.
True.
And if you then test, if the test shows that you've ingested some drugs.
Yes, sir.
I'm assuming that there is some protocol, there's some schedule that says if you test this, then you're gone.
It's set out.
Unless there's a zero tolerance. And is there zero tolerance?
Zero tolerance in the effect that if you score over a certain amount in the second test, okay, then you're pretty much gone. In this case, that's what happened. Mr. Jackson was given a random drug test in April 2019. He said that he didn't understand why he scored positive on the test. He said the only thing he could think of was he had drunk some homemade red wine made in Arkansas, and it made him woozy. That's the only reason he offered for why, but neither here nor there. He requested a second test on that sample, and the way they do that is, and this is across the board, the urine sample that you submit that goes to the testing place is in fact separated into two containers, as it were. So anybody that requests a second retest on that sample, they have the stuff to do it with. And that's what happened, and it came back, and it was a reconfirmed presence of THC. And on that basis, when the fire department
Didn't that test come back 15? I don't know what the NG is, but didn't that come back 15? And you said that that the baseline was 50.
I can't remember the math, but the two test results are in the record, and that seems to have been overlooked by the chancellor, the trial court.
But the second test is not positive, is it?
Second test was positive.
Well, that's the question about the zero tolerance, is what's the cutoff?
Well,
I
goodness,
thought you
right.
said the cutoff was 50.
It's set out in the order generated by the commissioner. And
Well, the reason that's important is because apparently the only test that was presented to the Civil Service Commission was a test that showed 15, not 50.
that's not true. That's a misconception, and it's in the record, and attached to the record are the results of both tests. Both tests. The original test and then the second test of the reconfirmation test.
Was that in the record at the Civil Service Commission also?
Yes, sir. And I believe it's cited in her order. Commissioner Lorraine Smith.
Was there any testimony before the Civil Service Commission as to what the results of the test showed to make it positive? In other words, what exactly was required?
No, and the reason why we relied on the certain cases established in Tennessee that do not require expert testimony in situations like that, and they're all outlined in my brief too.
So the test is self-certifying?
I believe so. If it's not, we accepted it, and we traveled on it. I've got a whole section in the brief that deals with that issue. And what I'm focusing on right now is simply the standard of review, which is, as you may know, it's TCA section sign 4-5-322, and specifically the subparagraph A4 and A5A. Simply put, a person who is aggrieved by a final decision in a contested case is entitled to a judicial review under this chapter, which shall be the only available method of judicial review. And then it says, the court may affirm the decision of the agency or remand the case for further proceedings. The court may reverse or modify the decision if the rights of the petitioner have been prejudiced because of administrative findings, inferences, conclusions, and decisions are, skipping down to 4, arbitrary or capricious or characterized by abuse of discretion or clearly unwarranted exercises of discretion, or unsupported by evidence that is both substantial and material in light of the entire record. That's the standard, and that's what we're traveling on. And we maintain that the Chancery Court, the trial court, didn't follow that standard at all. And
Let's go back to the commission hearing for just a moment.
Yes, sir.
Was there evidence introduced at the commission hearing as to what the cutoff was, what the prohibited amount of the testing would show?
in her findings, she references the test results, but I'm not sure there's any testimony as to the findings. There was a controversy raised by opposing counsel and a great deal of confusion about just what those numbers mean. The second test, I can tell you this, the second test is not the same as the first test. So there's a different category of what the numbers should mean, what's being tested, as it were. But I don't think that that's necessarily set out in her order. But she does reference the tests, both tests.
Well, how would she know what the cutoff is if there was no?
Well, in the order she cited the DOT guidelines, is saying that, in fact, the initial test cutoff is 50 ng over ml, and confirmatory cutoff concentration is 15 ng ml. So presumably she understood the difference in the two tests, and that's what we got.
Well, I'm trying to figure out, I mean, is this like a statutory scheme, or how would anyone know that? What the standard is?
I'm not sure, to tell you the truth. I don't know.
Okay.
But
I mean, if it's the law, good.
It may
You're
be.
presumed to know the law, but.
I don't know all the law, but I know a little bit.
Right.
But it may be in the city procedures and guidelines which are attached, that they are followed in determining what is and what isn't susceptible to termination, who is and who isn't subject, you know. But at any rate, that's pretty much, and I have outlined in the brief, the tenets of what is substantial and what's reasonable. And I can go on and on and on, but I presume this court knows that information, and I don't want to necessarily have to read my brief. But on the other hand, we did talk about, and I've raised it in my brief to you, and that's about the evidence that's allowable before the commission, which about the admissibility of the drug tests. And I cited a case that was an interesting case that had the case of Davis versus Shelby County. And this is a deputy sheriff that failed it some years ago, and he was terminated. He filed a petition for writ of certiorari in the Chancery Court. The Chancery Court found that they reaffirmed the board's decision. He took it up to this court, and this court said that the termination was based on it was not based on substantial and material evidence, because the decision was based on an inadmissible drug test. That seems to be part of the questions that are being asked here today. Was it an admissible drug test or not? And the appeal to the Supreme Court on the admissibility of the drug test, they held that strict adherence to the Tennessee rules of evidence is not required in procedures before the board. They cite the Tennessee rules of evidence do not apply to administrative hearings, but rather to court appearances. Tennessee Rule of Evidence 101. These rules shall govern evidence rulings in all trial courts of Tennessee, except as otherwise provided by statute or rule of the Tennessee Supreme Court. And Memphis doesn't have one. So it stands. The Memphis Civil Service Rules, Rule 16, the rules that pertain to the Civil Service Commission, the hearing officer shall admit and give probative effort to evidence admissible in a court, and when necessary to ascertain facts not reasonably susceptible to proof under the rules of court evidence not admissible thereunder, may be admitted if it is a type commonly relied upon by reasonably prudent people in the conduct of their affairs. And on that basis, you know, that's how we feel that admission was competent and admissible.
You've used your time, Mr. Waring.
That's all I really had to say. I wanted to underscore the standard of review, that it wasn't followed, it's all set out, and also the admissibility of that evidence.
Thank you.
Thank you. Thank you for your
You've still
patience.
got your rebuttal time.
If it may please the court, I'm Darrell O'Neill, and I represent the petitioner, the appellee in this matter, Mr. Karl Jackson. And we're here today to respectfully request this court affirm the decision of the trial court, because the trial court correctly determined that the evidence presented was incompetent. Judge Stafford, you started this thing off. First question, what is a failed drug test? That was my objection during the hearing, during the Civil Service Commission hearing. We have no expert testimony to identify what these numbers mean. We don't know. Then you ask the second question, is the city of Memphis has a zero tolerance? The answer to that question is no. But when you went to that third question about, is there any evidence of the cutoffs? According to the record, there's not. And that was the issue that the chancellor had when he reviewed this information. Chancellor Golden, Judge Golden, you said, was there any expert testimony in this particular case? Absolutely not. And that was one of my objections. How do we know any of this stuff? What do we know what these numbers mean? The city of Memphis could not explain that.
You didn't stipulate the report?
I don't stipulate. I don't stipulate.
I'm not surprised, but
As you always say, Judge Stafford, I'm anti. So I did not stipulate. But
Mr. O'Neill, I think one of the records I read said that you stipulated to the chain of custody. Was that correct?
That's the difference. That's the chain of custody issue.
Correct, but I'm not talking about to the validity, but you're not saying today that that is an error?
No, I'm not
Okay.
saying that I'm not contesting the chain of custody.
Okay, I just wanted to make that clear.
the sample, I'm assuming.
I'm
The
sorry.
chain of custody as to the sample.
Correct. But I want to take you to the.
Based on the rules of evidence that don't typically apply in these commission hearings, is the test result itself self-explanatory? In other words, I guess the question is, does it require expert proof based on the evidence? What's required as far as introduction of evidence is the test result itself that says that it's positive. Is that sufficient?
It is not, Your Honor. And I think counsel misled the court here. When the counsel said to the court that Davis versus Shelby County applies, it says that the rules of evidence doesn't apply in a civil service matter. That's just not true. Davis versus Shelby County was a county case. The city of Memphis falls under the UAPA. The Tennessee Supreme Court in Tidwell versus City of Memphis says all City of Memphis cases fall under the Uniform Administrative Procedures Act. The rules of evidence do apply in the Uniform Administrative Procedures Act. That's the different argument. And so let me tell you how we know nobody knows what's going on here. During the hearing, Mr. Warren was asked, and I quote, Mr. Warren was asked, what are the cutoffs? And his statement was, nobody knows. We don't have any testimony on that. That's what we were arguing about. Nobody knows what the cutoffs are. We have no testimony on that. And then he says, we have no testimony. Then he said, if you don't have any testimony on what the cutoffs are, what's competent evidence, how can it be positive? I objected to that. Then the commissioner specifically asked about the second test, just like you were asking about. What's the numbers on the second test? Well, the commissioner asked that same question. And here's the statement from the commissioner. And it's on the transcript, page 75, line 16. Specifically, she says, before I allow an answer, additional questions, Mr. Warren, everyone is referring to a retest. The retest results, are those available? Are those in the record? Mr. Warren says, they're in the record. The retest, and then the commissioner says, he asked for a retest. What were the results of the retesting? I don't see them. Mr. Warren, I believe they're in the record. Again, if they are not, we can make arrangements for them to get in the record. And then the commissioner says, I don't see them. As this court knows, every lawyer has a duty to point the court to the record. The court's not required to go there and comb through the record and try to figure out what's going on. My client, and the one fact that the city stated that I absolutely agree with, had 24 years and 2 months. He said, that test is not proper. That test is not correct. I want a retest. Now, throughout the Civil Service Commission and all throughout chance recording, you can look at the record yourself, they consistently said that Exhibit 11 was the retest. But if you look at the dates on Exhibit 11, it can't possibly be the retest because it's before the money was paid. So, I mean, there was all of this conversations about this retest, And then the city of Memphis, just like they did today, they conceded that, well, there is no evidence of what these numbers mean. It's supposed to be 50 nanograms. Well, it says 15 nanograms. Which one, what's right? Again, they put the onus on the commission to try to figure that out. And even though the trial court pre-terminated this issue, the question was whether or not the city of Memphis follows its own policies and procedures.
What was the date of the initial test? And by the initial test, I'm talking about the test that gives rise to this particular.
I think the date of the initial test was, one second, it was April 18th, 2019. And then, if you look there, and this is in the record, the transcript is Exhibit 4, Exhibit 8, and Exhibit 11. And if you look at those things, those documents show the original test, when my client received notification, was in April 25th. He paid the money for a retest. He paid that money for a retest after April 25th. So there's no way that Exhibit 11 could be the retest. It's just not possible. So when we said, and the commissioners asked that question, where's the retest? Where's the retest? It was never provided. And then now they did attach some things to the Chancery Court record that I've objected to because they were not proper, but so that is not supposed to be considered in the record. But
So,
again,
have you ever received a retest or the report from a retest, to your knowledge, or has the court?
only through the brief that I saw that the city wrote.
Okay. It's not part of the record.
I don't think it's part of the record.
Okay. That's your position.
That's my position, and I'm sticking by it. I'm sorry, Your Honor.
No, that's okay. I asked that question.
But the point of the matter is, what the chancellor ruled here is the evidence that was presented at the Civil Service Commission and that was presented to the trial court was incompetent. Because again, nobody on this bench knows what these rates, these numbers are. Nobody knows. And the onus is on the city to present their evidence. And they just didn't do it. And it's for those reasons, again, the other issue was pre-terminated, so I won't argue about that other.
Well, let me ask you one question, because I'm a little confused on this too.
Me too.
Is this litigation a result of the return to work agreement or the city's drug policy?
It's the city's drug policy.
Okay, so we can forget about the return to work
Yeah,
agreement.
it's the city's drug policy, because what ends up happening is, so the city says that they have a right to fire somebody if they have a positive test. But what they also do is say, when you have a first positive test, we're not going to fire you. We're going to put you in this 4-year program, and if you complete the program, then you get to come back to work. I mean, you get to stay on the job, as long as you don't have a second urinalysis, positive urinalysis within that 4-year period. So it still gets the same evaluation as an initial test results get for positive urinalysis. So they don't have a zero policy, a zero tolerance policy.
So after going through this program, after you successfully complete that program,
Right.
it's as if you don't have a prior. Is that correct?
They can use it. I won't go that far. It's not as if you don't have a prior results. That prior result goes to discipline. So that's what it goes to, the level of discipline.
Okay.
So if it's a first test, then they give you I think it's a 240-hour suspension if you have a positive urinalysis on the first test. And then they put you in that EAP program. If you have a positive urinalysis the second time, they terminate you. But again, you still have to meet the levels. Your urinalysis has to come to that cutoff level, above that level. And the problem in this case, we don't know what that is. Subject to the court's questions.
I mean, as I understand, your argument is basically that there was no proof as to what the positive level was.
Absolutely.
Is that essentially what it?
That is absolutely my argument. And that's the argument I made before the Civil Service Commission. I objected when she was talking about different things. I was objected about the record being presented into her without competent explanation of what this record means. And so, again, the only thing, Judge McGee, the only thing I did concede about is the chain of custody, but not about the competency of the results. For those reasons, we request that this court affirm the decision of the trial court. Thank you.
Thank you, sir. Mr. Waring, I believe you have 2 minutes.
That's all I'll need. Those tests are on the record. They are on the record. They came in as a collective exhibit, I believe, from Fire Chief Hope Lloyd. Both of, in fact, they're in there several times. The first test,
Let me ask you this. What do you say about Mr. O'Neill's argument that the rules of evidence do apply to the city of Memphis under the UAPA?
I'm not too familiar why it wouldn't, but
I mean, what you stated earlier was that essentially this, whatever documents you filed was self-certifying. There was no need for any extra evidence to prove what the documents were showing. But that wouldn't necessarily apply under the rules of evidence, would it?
wouldn't the rule of evidence 401 apply when it said, you know?
I don't know how it was introduced. I mean, there's no, was there an affidavit attached to it? Was it introduced as a
Oh, the test results?
business record or?
No. They
What
were
was
just, they were put forward. And I was traveling under the Davis case because I'm familiar with it.
Which is a Shelby, as he indicated, the Shelby County case, and he's saying that it's a different standard
You know,
as to the city of Memphis.
It may be. That's never been cited as any reason to differentiate it from the city.
Is Shelby County under the UAPA?
I believe they are. I think that, well, now, wait a minute. I'm pretty sure they are.
So is it your position that the rules of evidence apply or don't apply?
They don't apply.
Don't apply.
No.
All right.
I may be mistaken, but that's where,
Well, there's obviously
that's what
a question about that.
no, well, that's it. The records do reflect the tests that were in the record. Indeed, it simply says, split, reconfirmed for THC positive. Both of them, the documents look almost identical because they're a little bitty print, but it does give different dates, and one says the retest. And in fact, I believe I heard opposing counsel say that something about the money wasn't even received or something. I don't know about that because the test was administered on, I think, as soon as it got there, and the results came back to the city on May the 2nd. May the 3rd was the day the termination letter went out. So
Thank you, sir. You've used your time.
I've used my time already.
Yes, sir.
Thank you for your patience.
All right, we're going to take a brief recess, and we will be back in just a few moments. Gentlemen, we appreciate your arguments. We'll take this matter under advisement and attempt to render an opinion at the earliest possible time. Now we're going to take a brief recess, and